As I've said here before, education should never be measured just in terms of grades or CAO points, nor should it be geared towards preparing young people to be economic units ready for employment by multinationals, at least not primarily. Education should be about allowing children to become fully rounded human beings, and a vital part of that is allowing children to socialise with their peers and to have adequate time for sport and recreation. And indeed, our own happiest memories from school are not of books or exams, but of the bonds we made with friends. And all schools are required to deliver physical education as part of the curriculum, but that's only part of the story. Children should have as much fresh air and physical activity as they want and need in between class time. And I don't need to recite the trends in Ireland and further afield in relation to childhood obesity. It's a serious problem. Encouraging activity during school hours is one way of addressing it. Now, there's been a trend over the last decade or more for playground activities and ad hoc sports to be restricted in various ways by school management due to the fear of litigation arising from small accidents and minor injuries. Ball games are often curtailed or prohibited. Some schools have even implemented a so-called no running policy. And I have to say there's something particularly Kafkaesque and joyless, utterly joyless, about telling children not to run in a schoolyard. Yet we hear anecdotal evidence, at least, of that going on. Because aside from the fear of litigation, there is a more general trend in recent years, perhaps on the part of parents or some parents, state bodies and policymakers, to wrap children in cotton wool to shield them from any kind of negative experiences. But that's not a real-world approach, because cuts and bruises, falls and knocks are and should always be part of most children's lives. Now, the bill I'm sponsoring today recognises that reality by protecting schools from unjustified liability for everyday schoolyard accidents and allowing them to facilitate increased activity for children. It doesn't seek to bring any radical change to the law. The courts have on the whole been very sensible in this area, but I hope it brings some additional comfort to schools by codifying in legislation what has largely, though not always, been the view taken by the judiciary where disputes have arisen. Now, the issue of restriction of schoolyard activities is on the record of these houses. The Joint Oireachtas Committee on Children and Youth Affairs conducted 10 days of hearings into childhood obesity in 2018 and had a number of oral and written submissions, including from government departments. Its report of November 2018 said that the committee had heard evidence, albeit anecdotal, that children in some schools are being prevented from partaking in physical activity during break times due to restrictions being imposed by schools. This was as a result of schools being concerned about possible liabilities arising on behalf of the school where a child is injured while playing on the premises. The Teachers' Union of Ireland made a submission saying how schools were concerned about a litigious culture and talked about the logical but regrettable responses, including being so concerned that some have instigated limitations on students' physical activities, such as running in the schoolyard. The INTO referenced similar anecdotal evidence of no running policies, said, unfortunately, we're in a culture of litigation and boards of management are very exposed. So part of the problem here is that it's based on anecdotal evidence. We all know a problem exists, but we've little tangible proof that it can point to, and there are reasons for that that I'll come to. But the Joint Oireachtas Committee did propose a means of turning that anecdotal evidence into something more concrete. They recommended that the government survey schools to identify the scale of the issues. Now, curiously, they didn't seem to consider whether more than just encouragement of schools was needed, that perhaps new legislation would also help. The Minister Foley, in January 2021, responded to a written question in the Dáil. She'd been asked about actions her department had taken on foot of the report. She gave no indication that she had surveyed schools in line with that recommendation 13, and I'm not aware of it having been done in the meantime, and apologies if I ought to be aware, but I would be very interested to know whether there's been such a survey.
You're on 13 minutes. Oh no, sorry, wrong way, apologies,
Yeah,
sorry.
That's all right, stop the clock.
You're all right.
Now, a number of cases, Cairlig, have come before the courts in recent years where schools have been sued by parents on foot of schoolyard or sporting injuries, including an injured knee during high jump practice, a slip and fall during a hockey match, a broken arm during a game of chase, a child being struck in the eye with a chocolate bar by another child, and a child being hit in the eye by a pencil thrown by another child. And I think we can all agree that these are not the sort of things that should end up in the Circuit Court or the High Court normally, and yet they have. Thankfully, the judiciary has largely taken a common-sense approach, treating minor injuries as just that. In two recent High Court cases, Dunn v St Paul's School in 2019 and Cole v Sisters of Joseph of Clooney Killiney in 2016, the court ruled in favour of the schools in both cases, saying accidents can happen and the school is not automatically to blame, and that sport and playtime is an important part of the school experience, and no indoor or outdoor sport could be conducted if schools were held responsible for all injuries. The court dismissed another claim in 2017 as based on a broken arm as being an old-fashioned accident, pure and simple. They also said significantly that no prudent, responsible and reasonable parent would have prohibited the game of chase that had been taking place in the schoolyard on that day in that particular case. And that concept of a prudent parent is central to my bill, and it runs through many of the cases taken against schools. For example, in Maher v Presentation Junior School, Mullingar in 2004, the court said, and I quote, "The school is expected to be no more and no less vigilant of those in its care than a prudent parent would be in his or her own home." Now, also in 2004, the Supreme Court gave its view on the issue in Murphy v Wexford VEC, stressed the importance of schools having adequate and reasonable supervision in place relative to factors including the age of pupils, the number of students, the locations they congregate, and any other characteristics the schools are aware of, for example, any particularly troublesome students. The court said that no school could possibly supervise all students all the time, but that once adequate supervision was in place, a school should not then be held accountable for everyday accidents. Note, once adequate supervision is in place. And I think we'd all agree with that, and that's what this bill today seeks to ensure. But why is legislation needed if the courts are generally standing on the side of schools in the great majority of cases? Well, clearly, despite the courts being on side, schools are still apprehensive. Why else would they be imposing no running policies and so on? And there are a couple of possible reasons that I said I would get to. First, as we know, when it comes to insurance claims, there is an iceberg effect, whereby the only legal claims we see are those which are before the courts. Insurance companies are often willing to settle rather than to fight claims which they're confident of winning. This isn't due to laziness or incompetence, it's a simple cost-benefit analysis. The cost of fighting a case, particularly the prospect of not being able to recover legal costs if the schools win, will often lead insurers to go for a quick settlement. And this has the effect, of course, of adding to premiums for the school itself and for all schools, and adding to the anxieties of school management in relation to minor accidents. I don't say the direct result would be an increased premium in the individual case, but over time all schools would be affected. Second, teachers and school management are human beings operating in a high-stress environment and with limited budgets. The prospect of dealing with a phalanx of solicitors and barristers over schoolyard accidents is obviously far less preferable than the easier option of curtailing sports or implementing so-called no-running policies. I was also concerned to find, quite by accident, a firm of solicitors in Cork that loudly advertised its work in taking litigation against schools for such injuries. I would hope it was an isolated case, because if not, it would be the type of thing that would significantly add to the problem. Now, above all, however, we know that just because courts tend to side with schools now, that's no guarantee that this view will continue to apply in the future in the absence of clear legislative guidance. In the fourth edition of McMahon and Binchy's Law of Torts, which is agreed to be the seminal work in the Irish law in this area, the authors discuss, apologies to any rival writers and thinkers that might be in the room or elsewhere, I don't think so on this particular area, but nonetheless, the authors discuss in that book litigation against schools and warn that, and I quote, "The problems of care and control in a school bear some resemblance to those confronting a parent in the home, but they're far from identical. It is possible that in a future decision, an Irish court will draw the reference to careful parent and stress the fact, it's possible that a future decision in Irish court would drop the reference to careful parent and stress the fact that it's the standard of the reasonable school teacher or manager that should prevail." In other words, McMahon and Binchy warned that the standard of care might be changed in future. A higher standard of care might be expected of a teacher who is, after all, employed by the state than would be expected of a parent, which would then expose schools to significant additional liability. My bill today would preclude that possibility by writing the, quote, "the prudent parent test" into statute law. So the bill would insert a new Section 51Q into the Civil Liability Act 1961, and its effect are set out in the explanatory memorandum. In summary, subsection 1 would protect a school from liability for injury to a student on its premises, provided that it has an adequate system of supervision in place and that the school is in compliance with health and safety standards which are applicable to it under health and safety law and regulations which the Minister for Education can impose on it. And this would effectively codify the judgment of the Supreme Court in Murphy versus Wexford VEC, which found that it's not feasible to have all children under constant supervision, but a school does have a duty to have reasonable supervisions in place depending on the particular circumstances. Section 2, 3 and 4 protect a school from liability for any act done in good faith by a teacher, another staff member or a volunteer who intervenes in good faith, as I've said, to aid a child in an emergency, but where for whatever reason that good faith act ends up causing injury to the child. This mirrors the Good Samaritan provisions which already exist in the 1961 Act. Subsection 5 would enshrine in statute that the standard of care which applies to teachers and other school staff shall not be greater than the standard of care which would be expected of a reasonable and prudent parent, which again enshrines recent judicial practice into statute. It's important to note that if schools are absolved from negligence in such cases, parents cannot then seek to sue a teacher who has acted in good faith in the course of their employment. Under the law on vicarious liability, only a school could be held accountable for the actions of a teacher in the course of their employment. Under common law, a teacher could only be held accountable if they acted in bad faith or conducted themselves in a grossly negligent manner, and subsection 6 provides a standard carve-out recognising this. So that, Minister, is the bill. I'm aware of the fact that there is occupiers' liability earn the book on Mara Jersey de Connemara, that's on its way, but it doesn't cover schools. It does suggest, if you like, lessening the burden on occupiers, but it's my view that particular legislation is necessary to give the necessary comfort to schools in this context, mirroring, as I've said, the attitude generally taken by the courts, mindful, however, that there still appears to be a negative culture around playground recreation, and that the necessary bolstering of the protections for schools is desirable in legislation. It's on that basis that I am commending this bill to the House. I'm delighted that I have left more than